That's Debatable is sponsored by MB&G. MB&G is specialists in the esoteric world of vehicle and furniture warranty insurance, delivering quite marvellous customer service, prompt claims payment, and a highly developed understanding of how to deliver these products in a way that is both compliant with the regulations and attractive to customers. To find out more, call Paul Smith, the Managing Director, on 07887 501 441. That's 07887 501 441.
Welcome back to That's Debatable. This week we have a special episode with Toby Young, our General Secretary, and we're going to be talking about Lucy Connolly, which has been dominating free speech news over the last week because, of course, Lucy was released from prison last Thursday and gave two very big interviews, one with Alison Pearson and another with Dan Wootton. And I thought it'd be a good opportunity with you, Toby, to go through some of the arguments from the other side of the debate, people who think that Lucy should have been locked up, perhaps, for the grossly offensive tweet that she posted, and basically go through it and spell out why those arguments, or why we at the Free Speech Union disagree with them, and try and counteract them and untangle those very frustrating arguments, one such of them being that I faced a lot this week, but she pleaded guilty. So my first question to you, Toby, is the same one that Alison Pearson put to Lucy as her first question, and that is, was Lucy Connolly Starmer's political prisoner?
Just before we get onto that, Connie, let me just correct something you said. You described her tweet as grossly offensive. You're perfectly entitled to take that view personally, but that also has a legal meaning because it's unlawful under Section 207 of the Communications Act to publish something grossly offensive. And I don't think Lucy Connolly has ever been accused of doing that. So she wasn't found guilty, as we know, under the Communications Act, but under the Public Order Act. Is she a political prisoner? I suppose it depends on how broadly you define political prisoner. She certainly isn't a political prisoner in the conventional meaning of the term. She wasn't jailed because she was a member of a particular political party or because she expressed a verboten political point of view. I think it might in some ways be more credible to describe anyone who is imprisoned for expressing their support for Palestine action. No one has been yet, of course, but it might be more credible to describe them in due course as political prisoners if they are imprisoned. Because it would be specifically because they've expressed support for a particular prohibited organisation with a kind of political character. And that's not true in Lucy's case. I think you could nevertheless make an argument that politics played a part in the fact that she ended up being jailed for longer than a year. I think the fact that she wasn't granted bail, I think people who've, on the other side in the culture war, who've defended her sentence, have glossed over how much discretion the courts have when it comes to bail applications. I think it's implausible to say that the political climate will not have affected the judgment. I think there was a magistrates' court application and a Crown Court application for bail, both of which were refused. And this was in, a febrile environment in which Keir Starmer and indeed, I think, the Director of Public Prosecutions had announced that anyone participating, anyone contributing to the disorder following the Southport attacks would feel the full force of the law. And they were also very clear, Keir Starmer was particularly clear about this, that people who disseminated mis and disinformation, which contributed to the disorder, would be treated as just as culpable for the disorder as those participating in it. So, I think it stretches credulity to think that the courts that refused Lucy bail would have been completely oblivious, would have set aside those remarks, would have ignored the climate and just judged the matter according to the letter of the law. And I think the fact that she wasn't granted bail, so if we allow that that was a politically influenced decision, the fact that that decision was made, I think contributed to her decision to plead guilty. She was, as we know, anxious that if she pleaded not guilty, the trial date would be set so far in the future, partly because of the backlog, perhaps even to punish her, that may have been what she thought, that she'd end up spending more time in prison than if she pleaded guilty. Now, that was a miscalculation, I think. We don't know when the trial date would have been set for, but it feels like a miscalculation. And of course, there's a risk in pleading not guilty, because if you plead not guilty and you're found guilty, you end up with a longer sentence than if you plead not guilty. Than if you plead guilty. But clearly, the fact that she hadn't been granted bail made her more inclined to plead guilty. It entered into the calculus and made that a more rational choice. And in addition, it's hard to make rational decisions when you're being held on remand. Much easier to do so when you have the comfort and freedom of your own home. You're able to talk to your spouse, your close friends. You're able to seek proper legal advice at length. None of which she was able to do, and so I think calling her a political prisoner is probably a bit of a stretch. But I think the fact that she ended up in prison was a politically influenced matter. And I think one final thing to say about this, Connie, is that judges have a degree of discretion too, and Judge Melbourne Inman, I think, could have given her a suspended sentence instead of sentencing her to 31 months, although 31 months was within the range of the recommended or of the allowable sentences. But when he sentenced her, in his sentencing remarks, he did say, and I'm quoting here, "It is a strength of our society that it is both diverse and inclusive." And that suggests that he has completely bought into the kind of EDI ideology. And he was personally affronted by Lucy seemingly not having done so. She was flouting, in his eyes, trespassing upon what he regards as sacred values, diversity and inclusion. And many people who embrace those values don't think of them as political. I think that's naive. Of course they're political. And perhaps he thought it wasn't political to invoke diversity and inclusion when sentencing her to more than 2.5 years in jail. But that, to me, if you regard that particular outlook, those values, as being inherently political, the fact that he invoked them when giving her what I think was quite a severe sentence suggests that the sentencing decision was politically influenced too.
I wanted to go back then to the speech that you referenced that Keir Starmer made on the 4th of August, which was about 5 or 6 days before Lucy was charged, in which he said those who are getting involved with stirring up the violence online will be met with the full force of the law and individuals will be remanded. How is it that him giving that speech influences the courts, or does something happen behind the scenes that actually gives that order to the courts, or is simply the fact that he gave that speech enough to make the courts decide that that's what they're going to do? Because I personally find that quite concerning, that a prime minister can influence the courts in a speech like that when they're meant to be independent. And Keir Starmer says that he respects the fact that courts are independent, but actually, how can they be independent when his speech seemingly was so influential that it meant that and as well, at least Lucy says, that her solicitors were telling her that this never usually normally happens. People wouldn't normally be remanded for this type of alleged offence, but people are being remanded this time. How can that be the case, that the Prime Minister gives a speech like that and that happens? Is that just the nature of our system, or is there an actual official sort of thing that goes on behind the scenes that is an official route, or is it simply that speech that he made?
The judiciary isn't wholly independent when it comes to decisions of whether to prosecute. And certainly in this case, to prosecute someone for stirring up racial hatred, which is what Lucy was prosecuted for, that can't be done without the consent of the Attorney General, who was a politician and a member of the Labour cabinet. Is it possible that Keir Starmer and Lord Hermer had a conversation about whether or not Lucy should be prosecuted for stirring up racial hatred? I suppose it's possible. But I wouldn't have thought it likely that the Prime Minister would convey to the Director of Public Prosecutions that he wants, the book to be thrown at people like Lucy, and convey to, the judge in the case that he would like her to receive the maximum allowable sentence. I don't think that's necessary. I think the fact that he's using Number 10 as a bully pulpit to make his feelings clear, and I don't suppose you could get a cigarette paper between him and Judge Melbourne Inman and Stephen Parkinson, was that his name? The director of Public Prosecutions. I would have thought that often when people imagine that there is a degree of coordination when something like this happens, and that there is a conspiracy, they're overlooking the fact that people of a similar class, a similar outlook, a similar education, who move in the same social circles, who share the same political values, they move in lockstep without there needing to be any guiding hand. They are, as in that sense, Dominic Cummings uses the phrase non-player characters from video games. I mean, the way they react to events like this is absolutely 100% predictable. Why would Keir Starmer need to risk picking up the phone to the Director of Public Prosecutions when he knows that he's going to share everything that Keir Starmer thinks? Just an unnecessary risk. And I think the fact that Keir Starmer is himself a former Director of Public Prosecutions and a well-respected lawyer means that his words carry additional weight. Mm-hmm. With the judiciary.
Going back to, you've partially covered it already, the argument specifically, but she pleaded guilty, and people will say, well, she had the same access to advice that anyone else would have, and she just chose the wrong thing. She chose the wrong decision to plead guilty, and she could have easily chosen in exactly the same way to plead not guilty. are we able to, is there any clarity that the listeners can get on what exactly it was that she was being advised? Because I think for a lot of people, they simply cannot see past the fact that there is the possibility that the advice that she got simply wasn't very good advice. And that seems to me a large reason for why she was absolutely convinced that pleading guilty, despite what her husband was saying at the time, Ray, at least she, from her interviews, says that he was urging her to, consider the other option, but she was set on pleading guilty. Is there any clarity that we can give to people about why, exactly what sort of advice she would have been getting, or seemingly what the advice was? And had she been released on bail, why that would have made a difference? And how is it possible that two different lawyers, why is it that an external solicitor may have given different advice to a duty solicitor, for example?
Well, we don't know that her decision to plead guilty was a mistake, because we don't know whether, had she pleaded not guilty, she would have been acquitted. She might have been found guilty, in which case her decision to plead guilty was correct, or rational at any rate. Now, we did take on a similar-ish case at the Free Speech Union. Jamie Michael, former Royal Marine, also prosecuted for stirring up racial hatred, and he did plead not guilty, and we paid for his defence, and it took a jury all of 17 minutes to universally acquit him. That was, I think, probably an easier case to win than Lucy's case would have been had she pleaded not guilty. He posted a 12-minute video on Facebook. Like Lucy, he did it when the identity of the Southport attacker was still unknown, and wrongly thought that the attacker was an asylum seeker. And he was urging his followers on Facebook to protest against illegal immigration. But he was urging them to protest peacefully. He wasn't urging them to break the law or try and intimidate politicians, certainly not to burn down asylum hotels. I think it's obviously an interesting hypothetical to think about whether, had Lucy pleaded not guilty, she would have been acquitted. I think she could have made two strong points in her defence. First of all, in her tweet, she did add the caveat, "for all I care." So the defence could have argued that she wasn't urging people to burn down asylum hotels. She was expressing her indifference, should they choose to do that, which isn't incitement in the ordinary understanding of the word. And in addition, I think she could have made the argument, or her defence could have made the argument, that even if she was urging people to burn down hotels full of asylum seekers, why is that racist? Why is that stirring up racial hatred? After all, asylum seekers aren't all of one race. And in fact, some of them might be Albanian. And therefore, a similar race, if not an identical race, to Lucy Connolly. Now, there is an interesting House of Lords case, back when the House of Lords was the highest court of appeal for the creation of the Supreme Court, in which the Law Lords concluded that immigrants, so anti-immigration sentiment, stirring up hatred against immigrants, did fall within the category of stirring up racial hatred, because even though they were of different races, nevertheless they were all collectively of a different race to us. I mean, I think that's quite a tenuous argument, and it would have been interesting to challenge it as part of Lucy's defence, and interesting to discover how a jury would have felt about that. Being anti-immigration, is that stirring up racial hatred? Is it reasonable? Does it make sense to regard immigrants as belonging to a particular race, or belonging to various races? I don't know. I think you could have made an argument along those lines. But parking that. So we don't know for sure that her plea was necessarily irrational. Although I think at the time the Free Speech Union, via Ray, did urge Lucy to plead not guilty because we thought we could make a decent fist of defending her. And there was a second part to your question as well. I've now forgotten what it was.
I'm not sure whether it's answerable, to be honest, but if something that I've been wondering, and I've been seeing because I've been seeing this being said online, the idea about the advice that she was getting.
Well, I think we have to be quite careful here because we don't want to defame her solicitor. And he wasn't a duty solicitor. He was a solicitor employed by Lucy. And one of the reasons she ended up getting such a severe sentence is because she pleaded guilty to, I think, 91A of the Public Order Act, which is intending to stir up racial hatred. I think that's often got lost in this kind of debate. She wasn't found guilty of stirring up racial hatred, or even of saying something likely to stir up racial hatred. She pleaded guilty just to intending to stir up racial hatred. But there are various degrees of that particular offence, and which relate to how culpable you are. And one of the forms of culpability you can effectively plead guilty to is intending to incite serious violence, which is the most serious form of the 91A offence, intending to stir up racial hatred. And she did plead guilty to that. And her appeal, which the Free Speech Union paid for in front of the High Court earlier this year when we appealed the sentence, the appeal partly turned on, well, did Lucy understand what she was pleading to? Did she understand the implications as far as her sentence was concerned when she pleaded guilty to the most serious form of intending to stir up racial hatred, namely intending to incite serious violence? And Lucy claimed that she hadn't understood that and that her solicitor had not explained it to her properly. Whereas the solicitor said, no, I did explain it to her and she did understand it. She knew what she was doing. And the judges found, effectively on that point anyway, for the solicitor rather than Lucy. They found his account more credible than hers. I think someone thinking about it rationally probably wouldn't, plead to the most serious form of that offence, knowing the implications for sentencing. But it's possible, I suppose, that she was under a lot of pressure and just wanted to, get things over with, and didn't want to kind of quibble or get into a prolonged dispute about exactly what form of that offence she was guilty of. I don't know. But I think it would be unwise, I think, to entirely take Lucy's side on that issue, given that the High Court found for her solicitor, and we don't want to defame her solicitor. Perhaps he's telling the truth.
And on the subject of the appeal of the sentencing in May, that's another argument that people make, that not only did Lucy choose to plead guilty, but at the appeal, all of the arguments were dismissed. Why is it that you believe, or the FSU believes, that those arguments were good enough? One of them being, like you just said, that she didn't fully understand what she was pleading to.
My understanding is, I might have got this wrong, Connie, but my understanding is Judge Melbourne Inman did not give Lucy the maximum allowable sentence, given what she had pleaded guilty to. And I think this argument came up. I think the other limb of the appellant's case was that the judge didn't take all the mitigating factors into account when sentencing her. And the Crown's argument is that he did take those mitigating factors into account, could have given her an even more severe sentence, but only gave her 31 months because he did take those mitigating factors into account. I mean, it sounds sort of scarcely credible because 31 months seems like such a severe sentence for a single tweet that was deleted within 4 hours and which he subsequently apologised for. But in his sentencing remarks, he does refer to the fact that she deleted the tweet and apologised for it. I mean, I think in a sense, the argument about, should she have been given such a long sentence? Should she have pleaded guilty? Would she have pleaded guilty if she'd been granted bail? Should she have been granted bail? Was the decision to refuse bail a politically influenced decision, and so forth? They slightly distract us from what should be a more important argument here, which is about the stirring up provisions of the Public Order Act, and particularly the provisions relating to stirring up racial hatred. And it seems to me that they are just clearly wrong. I mean, even if under the law Lucy was guilty of intending to stir up racial hatred, it just doesn't seem right that someone can be sentenced to more than 2.5 years merely for a malign intention. And under the Public Order Act, you can go to jail if you either intend to stir up racial hatred or say something, publish something which is likely to stir up racial hatred. And that again seems far too broad a test. Why not make it necessary for both limbs of that test to be satisfied before someone can be sent to prison? I prefer the Brandenburg test, which was set in place in a famous First Amendment case in America, Brandenburg versus Ohio. And the Brandenburg test is, and speech has to fail this test in order to be prosecutable, in order not to enjoy the protection of the First Amendment in the United States. The Brandenburg test is what you're saying or doing likely to cause imminent lawless action? And is what you're saying or doing intended to cause imminent lawless action? Now, cause is certainly clearer than stir up, which is a bit vague. But more importantly, both of those limbs have to be satisfied. And I don't think in Lucy Connolly's case either limb was satisfied. I mean, to take the was what she said likely to cause imminent lawless action? Well, in the United States, the reason neo-Nazis can march through Jewish neighborhoods chanting "Kill the Jews" and enjoy the protection of the First Amendment is because "Kill the Jews" is too broad. It's too non-specific. If they were urging members of a particular community to kill a particular Jew or burn down a particular synagogue or a Jewish-owned business, then that wouldn't be protected by the First Amendment. But because it's a broader command, then it's not. One difficulty is how can you show beyond reasonable doubt, even if a Jew is killed after a group of neo-Nazis march through a Jewish neighborhood chanting "Kill the Jews," that the Jew's death is a direct consequence, is caused by the chant. You could, I think, demonstrate that beyond a reasonable doubt if they're urging a particular Jew to be killed and that particular Jew is killed. But in Lucy's case, to relate this to Lucy's case, she wasn't urging her followers to. I mean, first of all, she just wasn't urging people to burn down asylum hotels full stop. She was saying, if you do, I don't care. But even if she had been urging her followers to burn down asylum hotels, if she hadn't added the caveat, for all I care, I think that still wouldn't have fallen foul of the Brandenburg test, because she didn't identify a particular asylum hotel that she was urging her followers to burn down. I mean, people said it's quite right that she went to prison because following her tweet, asylum hotels were set on fire. Well, that seems to me to be far too broad a standard with which to justify prosecuting people for saying things, intemperate things on Twitter, on X. I think you have to be able to show, an unbroken causal chain, showing that what someone said directly led to, lawless action, to violence. I think, yes, asylum hotels were set on fire after Lucy's tweet, but how do we know that wouldn't have happened anyway? I think in order to show that causal connection, to justify imprisoning her, you would need to show both that she intended a particular asylum hotel to be burnt down and that a particular asylum hotel was likely to be burnt down as a result of what she tweeted. And she didn't identify any particular asylum hotel. So I think Britain and America have different standards when it comes to incitement, and the standard here, the prosecutorial threshold, is much, much lower than it is in the United States. And I think the real issue here is that it should be higher. People should not be going to prison for, saying intemperate, even nasty things on social media, unless you can show, beyond a reasonable doubt, that those things were both intended to cause particular violence and did cause particular violence.